put your hands up. I'm going to be sharing a video from today, so I'll be starting the recording. Oh, I think maybe Verity's already started the recording, so thanks very much, Verity. Marvellous. So for any of your unlucky colleagues who couldn't be here live today, we've got that video there to share. So without further ado, introducing Verity and her team to set the scene about the Ombudsman.
Morning. Thank you very much, Ray. As we said, I'm Verity Richards. I'm also joined by Chris Simpson and Kirsty Noakes. We have all been with the Ombudsman for some time now, so we are very hopeful that we will be able to give you a good scene setting, but also answer some of the questions that you have. And Chris, I believe you've got some slides that you're happy to share.
I have, yeah. Morning, everyone. Lovely to see you all. I was looking at some of the questions submitted, and I thought it'd just be useful to just do some very quick slides just on our role and some of the numbers, just so that we're all starting off in the same place of understanding who we are and what we do. So I'll just share these quickly first. So bear with me a second.
That's lovely. They're showing now, Chris.
Okay, so who are we? So very quickly, just going over some basics. So we are the Housing Ombudsman service. We are a dispute resolution service. That's our core role. And our vision is quite an ambitious one, and it is improving residents' lives and landlord services through housing complaints. So that's what we're trying to do. And we do that in a kind of two distinct ways, really. One is our core role of making the final decision on disputes between residents and our member landlords. Our decisions are independent, impartial and fair. We also do that by supporting effective landlord-tenant dispute resolution by others, including landlords themselves, and we promote positive change in the sector. So our role is a statutory one, and it's set out in the Housing Act 1996, and the Housing Ombudsman scheme is approved by the Secretary of State. So just to give you an idea of some numbers in terms of our size, so we have over 1,700 member landlords, mainly made up of all social housing providers in England, which is all housing associations, all local authorities. We also have a small number of voluntary private providers too, but over 1,700 member landlords in total, and that means that we cover effectively 4.9 million households, so quite a significant reach. In terms of the impact we make, last year alone we made more than 22,000 orders as part of our investigations, either for redress, to put things right, or for things to improve.
And I think just before we move on, Chris, just highlighting with our member landlords is a really wide variety of different types of organisations that we cover within that membership. So we do have some very, very small providers. In fact, we actually have some providers who only have one property. So very, very small charities, for example, with historic arrangements, sort of right all the way through. So a landlord with one property, right through to really large organisations with over 120,000 properties that they're covering. We are responsible for the dispute resolution, as Chris has said, for those individual cases, but also promoting that learning. So there's a huge variety of the different organisations that we see, even within a local authority. I'm sure you'll be aware that you've got local authorities who provide their landlord services directly, but some may have an arm's length body, so they may have an ALMO, so an arm's length management organisation, or a tenant management organisation. So we do cover all of those as well. So it is a really, really broad sort of stretch across all of those different organisations. In terms of voluntary providers, there's over 75 now, so quite a large number of voluntary providers. Some are quite small, but some of them are larger with over 1,000 properties that have chosen to be members of our scheme. Thanks, Chris.
Thank you, Verity. Few more numbers for you now, and this is more about the last year, really. So looking from, we have expanded quite a lot in the last year or two, and we've got a lot busier, and the impact we're having in the sector has got a lot greater too. So just some numbers here to sum some of that up. So last year, so 23-24, we received 2,000 more cases for investigation than we did the year before that. So that's the sort of leveling increase in demand we're seeing. 2,000 more cases this year to last. In terms of our impact and the intervention that we make on cases, last year we found maladministration, which is our finding. So when we have investigated and determined that something has gone wrong, that hasn't been put right, we find maladministration. We found that in 73% of the cases we investigated. So nearly 3/4 of our cases, we found something wasn't right. And again, compared to the year before, that's quite a rise from 59% in 22-23. In terms of the remedies, so when we determine that something has gone wrong, there's various things we can do in terms of apologies, paying compensation, carrying out works, learning. Just in terms of compensation, our sort of remedies totaled £6 million last year. And again, looking to the year before that, you'll see there's a really significant rise. It was only 1.1 in the year before that. So a huge rise in the sort of our compensation orders that we're making in the last year. And again, that figures come up on the previous slide, 22,000 orders. So that's on all our cases, the orders we made. And again, huge improvement or increase from 6,500 orders the year before. So we're making a lot more orders on a lot more cases, ordering more compensation. Anything more on that one, Verity?
No, I think it's just important to sort of highlight, really. I mean, that is, as you can imagine, and that's a significant increase in orders of compensation, and we really recognise that can, that impact that not only can that have on the residents, because it is money that is needed to put things right in many cases, and to put them back into the position that they might have, we would expect them to have been had the issue been addressed appropriately, but also in recognition of the impact that potentially ongoing situations have had for quite long, quite long periods of time. So where a situation has been allowed to drift or hasn't been resolved, particularly in relation to property condition, actually that level of compensation can be very high. But we also recognise the impact that potentially has on our member landlords. That's £6 million that potentially could have been put into frontline services. So actually doing the repairs right first time, and actually reinvesting in those properties, which we know is something which is really important for the sector and also for residents. So whilst we are, I don't want to say happy that we've had to make those orders, our real focus is to try and to use wider learning across our membership to reduce and prevent this from happening in the future, because that's actually the best. Prevention is better than cure, and that's the really important thing that we're trying to work on. So as Chris said, we have a dual responsibility as an ombudsman service, so putting things right for individuals, but then also promoting learning through those. I did see a question come in about have we increased per case? If Chris doesn't know, it's one we'll take away and come back to you on, because I don't know off the top of my head and I wouldn't want to give you incorrect information.
I think it's fair to say we have. I think there's been a drive over the last year or two, and Rick, the Ombudsman himself, is quite open about the fact that he wanted to see our address align more closely to the type of redress that, particularly in disrepair cases, that people might get through the courts. I mean, certainly not the same, but I think we were a long way from that. So I think there has been an increase in the sort of level of orders we'd make for similar cases. Shall I move on to the last one? So I thought it'd be useful for us to just go through the sort of interventions that we make in the various stages of our processes, because this will no doubt be helpful for you guys when you're supporting residents to approach us. And there's sort of some key parts in our process, really, which is the initial part, which we call dispute support, which is the early stage of our process. And then the second part is dispute resolution, where we're making those decisions and issuing those investigations. So I wondered, Verity or Kirsty, do you want to say anything about a little bit about what we do at dispute support, and then I can do dispute resolution?
Yep, I'm happy to. I'm afraid, Kirsty, I can't see you. So if you'd like to jump in, then please, absolutely do.
I was just responding to the question in the chat, so I'll do that.
Okay, so just for a bit of context, so in a previous life, I was the head of dispute support, and Kirsty worked for me as a dispute support manager. So we are well versed in that support. So in terms of dispute support, that is the offering that we make to social housing residents and their representatives throughout the time that a complaint is within the landlord's own complaints process. The key purpose is, or the three main purposes, is firstly to make sure that residents are aware of their right to raise a complaint. So we do have an inquiries team. They will handle those inquiries where a resident will contact to say, you know, I'm very unhappy, I want to complain about my landlord, and providing that guidance and support so that we are able to signpost them to the right information, but also make sure that they know that they have the right to contact us at any time if they're unhappy with how their complaint is being progressed. So that's the first, so advice and support. We also have powers in our dispute support function. It's a power that is unique to us as the Housing Ombudsman, and that is to intervene where there's evidence that a landlord has failed to provide a response in line with our complaint handling code. So where a landlord is either delaying or refusing to accept a complaint, where a response isn't provided within a timely way at either stage 1 or stage 2, we have powers to ensure that that complaint is being responded to by the landlord and any member of our scheme. Where we do so, that case will be allocated to an advisor who will then review the individual circumstances, and they will then intervene with the landlord. Through that process, they will then track and monitor that case to make sure that either the resident is given a clear reason as to why it's not appropriate for a complaint to be raised, and in which case we can consider that decision for investigation, but then also making sure that that complaint is responded to and that the resident is either satisfied with the outcome of their complaint, or that they would like to refer their case to the Ombudsman for formal investigation. Residents can only refer their case for formal investigation where a final response has been provided by the landlord. That's usually, but not always, at the second stage of their complaints process, where they have 2 stages, which they should all have now with the statutory complaint handling code. There are some instances where landlords will refuse to escalate a complaint. Where they do so, we can then accept that for investigation. So a resident isn't left in a limbo of, well, actually, I want to escalate the complaint, landlord says no, and then they can't access our service. So once that information, we have confirmation, residents are then free to refer their case to the Housing Ombudsman for formal dispute resolution and that's the point that we would then look to hand the case over. When they're doing that, there are certain things that we do need to consider. Firstly, do they have the right to make to refer their complaints? So is there a tenant-landlord relationship? Are they an applicant for social housing, or if they're a representative of either the person or unfortunately the estate, and whether we have the right permissions and the right authorisations in place. We will also consider whether the particular issue, the substantive issue, is within our jurisdiction. All of that jurisdiction is set out in our scheme, but it's very important that we aren't overstepping our legal powers and our legal duties. So we will do that check at that point, and we'll look at evidence to see whether that is the case. The approach that we're taking in terms of considering jurisdiction, I say sort of broadly speaking, is if in doubt, it's not out. So if we're not sure whether a case is fully within our jurisdiction, we will make every effort to adjudicate that case until we see evidence to the contrary. So we're not forming a barrier to access to redress in that space. I'll hand back to you, Chris, for the dispute resolution.
Thank you, Verity. So yeah, dispute resolution, the case will come to us, so we know that the landlord have provided a final response to that. So then our decision at that point is how are we going to resolve that dispute. Initially, we may consider if it's suitable for resolution through mediation, or what we used to call early resolution. So we can look and see if we consider the parties are not too far apart in what they're looking for from the complaint. Get an understanding of what the resident is seeking as an outcome from their complaint, and from speaking to the landlord, understand kind of their position as well. If we think it's worthwhile engaging in, we call it mediation, it's not quite proper mediation, it's more sort of shuttle diplomacy in terms of just trying to work with both sides to kind of reach an agreed solution. It's quite labour intensive. We haven't done as much of that over the last year as we'd like to, but we've been very busy, but it's something that we're keen on pushing again. So you may see over the next year that as an increase from us in that sort of offer to try and engage and support people in reaching mediated responses. Where it works brilliantly. Landlords don't have to provide evidence to us. Residents are obviously integral to the decision, so they're involved and they have buy-in into what happens, and we don't have to actually investigate and carry out that part. So it's kind of where it works great. So that's one option, and if we can do that, then we will. If not, then we'll proceed with a formal investigation. So we'll seek evidence from both parties, and then we'll carry out an impartial inquisitorial investigation of what happened for that particular complaint. And that's when we issue our determinations at the end of that. So an investigation report that sets out whether we think there has been maladministration or not. If we are finding failures, then we're also making orders. So our orders are enforceable under the scheme. Landlords are obliged to comply with the orders we make, and the type of things we can do. Initially, obviously, our orders need to be focused on putting things right for the residents. So we're interested in apologies, particularly paying compensation if we think there has been detriment to the resident, carrying out any works if it's repairs related to make sure that there's sort of any outstanding repairs issues are dealt with. But particularly now, a much bigger focus on learning as well. So we need to know and see that the landlord has done the learning for the complaint. If it hasn't, then we'll make orders for it to go away and do that, sort of carry out investigations itself or management investigations to investigate exactly what went wrong and why, and what steps they intend to take in future to put things right. So there's a real focus with our orders, not just on redress in terms of learning and sort of improving services going forward. I think I'll leave it there. I was going to move on to wider orders, but I don't think that's particularly, we'll leave that for today, I think. Okay, so I think that's it really for an overview, Ray, so I'll leave it there.
Yep, and then I can pick up the point. I was just going to say on the sharing of learning, we've done quite a significant amount of work to increase our learning. We've increased our spotlight reports, our damp and mould, our knowledge and information management, and lots of different areas, and we're really trying to build on that, because as I said before, this is about working with the sector to prevent this from happening in the future. So we aim to really pull together not only from individual cases, which is really important, but those themes and trends, so we can support the sector to learn and develop and take things further, whilst recognising that there is a real difference in how they can be applied depending on the organisation. So thanks for letting me hop in there, Ray.
No, marvellous. Well, then we'll skip on to the next part of the agenda, which is the pre-submitted questions part, where I think your team have just kind of looked at the kind of common themes and the common topics of the question. So it's over to Chris and Kirsty now for this bit, but please do use the chat function as well if you've got any burning questions that pop up in your head. Thank you.
Sorry, we're all looking at each other. So I can see here. Yeah. So the first question that we had come through was from Sharon Whitehorn, sort of asking about general information about what we do and on our timescales and the process, which hopefully we've sort of followed through there, about what our process is. There were lots of interested questions about average timescales, time to provide responses, and I'm afraid it is a slightly ombudsman response, which is it depends on the individual cases. And the reason that I say that is that the way that we are working, and bearing in mind we've had such a significant increase in contact and demand from some very, very vulnerable people, or not vulnerable, but people in really, really difficult situations, some of which may be ongoing. So for example, they may still have damp and mold in their property, and recognizing that actually they may pose a greater risk for impact and detriment to the individual. So we actually consider that as part of our allocations process. So it is very difficult to say how long on average it will take for those different areas. As a general point, Chris, have you got anything that you'd want to add on the dispute resolution timescales?
Yeah, I guess just to say, and I was looking at some of the questions, because we're allocating cases by risk now, as Verity says, so we'll look for a number of risk factors, which might be vulnerability if the issue is outstanding. So let's say particularly, I think one of the questions related to damp and mold and ongoing damp and mold. So if a complaint comes to us and a resident has a final response to that complaint, when we progress that through our system, it's highly likely that that will come out as a high risk case. There's an ongoing housing situation, vulnerable resident. It's going to hit a lot of high risk factors. So it then is effectively fast tracked through our system. So we have a KPI at the moment that we have to ensure that no high risk case goes over 6 months. In reality, that means that and some will be determined much sooner. So I'm sure the days of where people might have a case like that may still wait a year or two, going back the last couple of years, is certainly not happening now. So if a resident has a case that we determine to be high risk, it will be determined within 6 months, and it could be determined in kind of 3 or 4. We're seeing some come through very quickly and actually be determined with those type of timescale.
That's great. Moving on to the next questions. So there were several which were from Kath and Elaine, which is really about understanding the powers that we have and the role of the Ombudsman, which I think we've hopefully covered. If not, please do pop any of the extra questions in the chat. We're more than happy to do that. In terms of our powers, so as we've said, we have the Ombudsman. So our power traditionally has been to resolve disputes between landlords and between social landlords in England and tenants. That does include applicants for social housing, but just highlight not under homelessness applications. That sits separately to us with the local government and social care ombudsman. And I know there's some questions about our working arrangements there. As I've said, we do have powers to intervene on individual cases, while the landlords and the tenant, it's still in the landlord's own processes, and we can intervene and we can order the landlord to take action and provide that response. Ultimately, that can end in a complaint handling failure order, which we publish. We share that with the regulator, and we can take those forward. So that's on our individual cases. We have powers to issue orders and recommendations. We will track the compliance of those orders. If they're not complied with, we can issue a complaint handling failure order. And ultimately, we do have set out in our scheme the ability to apply to the Secretary of State to escalate those orders for court action. We haven't had to do that, and I have to say compliance with our orders is generally very high across organisations, but it is something that we have there. More widely, we also have powers to issue a statutory complaint handling code that was set out in the Social Housing Regulation Act. With great power comes great responsibility. I know I say it all the time, but it is true, which is why my team has been set up, because by issuing a complaint handling code, which is statutory, we now have a statutory duty to monitor compliance. So by law, the Housing Ombudsman must monitor compliance with that code for all members. We also have the powers to issue good practice. So in terms of issuing good practice, that is identifying areas of sector provision which we have seen, and we're satisfied that we've seen good practice that we would expect landlords to consider as part of their service provision. And in order to do that, we would go through consultation, we would reach out for experts, and we would make sure that that's there. We can then require landlords to complete a self-assessment against that good practice. So we do have those. Chris highlighted wider orders, so we also have the ability the powers to issue wider orders, and that's to put things right for anyone that is affected beyond the individual case. So for example, if one resident has been affected in a particular way, I sort of use communal doors as quite a good example, and finding the impact that they've had, we can then order the landlord to pay the same level of compensation to all residents in that particular block that have been affected in the same way. But not only that, we can also order landlords to conduct learning reports, to review service provision, to review their policies and to review their approaches, which we will then track through to completion. So that would be my answer to powers. Again, if there is any more questions on that, then please do pop them in the chat. The next question that we've got here is from Brenda, which is about disrepairs, mould and dampness in social housing in Westminster is a constant and real issue. However, so many tenants are disheartened to know it can take a while for us to look at the issue, and what are the timescales, and also what is being done to improve the timescales. We've covered that really already. I think, Chris, you've given that overview, particularly on the timescales. And just more broadly, I mean, we've been through a huge expansion as an organisation. So when I joined 3 years ago, there were 125 people at the Housing Ombudsman. We are now upwards of, I believe we're hitting nearly 500. I always say we're at 500. We're not quite there, I don't think, but we are planning during this year through expansion to reach 500. So you can see it's been a huge increase. We would all like to do our determinations more swiftly, but the challenge is that as we are seeing the cases coming through, they are becoming more complicated, and that's demonstrated by the increase in the number of orders and findings that we're finding on those individual cases. It's not straightforward missed appointments. You know, it is really complicated cases which deserve the time for us to investigate them in full. On those, I'm just looking at the next questions. So Julie had asked about an overview of our processes to advise clients. So I think we've covered that, but Julie, if you're in the room and you want to ask any more, please do come through to that. The next question that we've got really relate to access to the Housing Ombudsman. And the first one's from Nikki. saying a lot of our clients have literacy difficulties and are also suspicious of authority and its forms. Is there any way to alter what you accept as clients' consent to act? As we have had several clients who refuse to fill in the consent form from your department sent through, but they were okay with ours. Kirsty, I'm not sure if you want to give a view on that one.
So our position used to be, if the consent form from a third party, so shelter, CAB, whatever, had the Housing Ombudsman as a named body that the resident was consenting you to contact, we would accept that. What we couldn't accept was a generic form saying, I used to work at shelter, so I'm familiar with these forms, but saying, you know, I give you consent to contact whatever organisations you deem appropriate. For us to be satisfied that the resident has explicitly consented to you sharing their data with us, that's too vague. So if you can include something specifically listing us as an authorised organisation, I suspect we probably would accept it, but we can't take something generic, no.
Yeah, and just to add to that, we would look at them on a case-by-case basis. So if you do have one that a resident, you've built that trust, because we do recognise that, you know, that suspicion of authority forms particularly, what we would recommend is to have that confirmed, you know, potentially through your own processes, have it signed or agreed, and then being able to move that forward, and we can look on a case-by-case basis for any of those. Because as Kirsty said, because of the sensitivity of the information that we may be processing, we have to be absolutely sure that there is authority. The next question that we have is from Cal. Apologies if I say your name wrong, Calthor. What help can you give tenants who do not speak English and have not received interpretation services and are asked to sign for rented properties as part of the tenancy agreement and then are charged thousands of pounds? So, Chris, would you like to? I saw you nodding. Would you like to?
I mean, the advice there, I guess, would be our standard advice, which is, and I guess that's one thing with all of these is our advice is always to raise a formal complaint with the landlord and allow the landlord the chance to respond to that. So in this case, if the resident's not had an appropriate chance to really understand what they're signing for, or kind of not had appropriate services put in place to help them understand the sign-up process, then we'd encourage them to raise a complaint as we would everybody else. So raise a complaint with the landlord, progress that through the complaints process, allow them to respond and possibly put that right themselves. If the resident's experiencing any problems in making that complaint or progressing it, then come to us and we can assist with that. Assuming that they reach the point where they've had a final response, the landlord has responded and the resident's still not happy with the landlord's response, then the resident should be able to bring that to us for formal investigation, and then that's something that we could investigate and decide on, or whether that has, you know, it's obviously it's tricky to sort of discuss live cases here on sort of very limited evidence or suggest what a decision might be, but in terms of what advice, that would be the advice really, to follow that process, see if you can get resolution with the landlord. If not, come to us. If you're having trouble progressing your complaint, come to us, and then we can formally investigate that. Ultimately, yeah. I hope that helps. So,
and what I think it also opens is actually there's two other questions which may be sort of kind of linked to that, because the you know, not all social housing, you know, they're very different provisions, and obviously there are different organisations which will maybe provide white goods, excuse me, but in terms of furnished properties, that quite often we find that related to private landlords, and we've got two questions about arrangements with private landlords. So Paula and Jenna have asked for information about, does the Housing Ombudsman deal with private landlords as well as housing associations? And Jen has asked, this isn't necessarily a question, but I'd like more information about how to address uncooperative private landlords. So at this time, the Housing Ombudsman does not have jurisdiction for private landlords. It's only for registered social providers or voluntary members. So we we wouldn't have any jurisdiction over those, and we can't really give any advice other than, you know, the usual sort of contacting and making contact with them because they're outside of our jurisdiction. So that would be something that we're not able to comment on, I'm afraid. And then, excuse me, in terms of other redress schemes, there has been, you know, we are awaiting confirmation on the next stages of the reform that is being looked at the moment for relating to private landlords and the potential for there being a private rental scheme. But we are, as the rest of the sector is, now awaiting that. So that's, I'm afraid, where we are with those.
We do, just on the redress scheme point, we do have 6 monthly meetings as part of the whole Ombudsman Association. So that will be different housing redress providers, energy, you know, lots of different public service ombudsmen. And that's generally frontline teams talking about issues that they're seeing, coming across, trends, etc. And there is a kind of sharing of knowledge within that. So we do have meetings with other redress schemes to see, as I say, what trends are going on. But given we all have quite specific jurisdiction, you know, there would be a limit to how much crossover there would be between us.
Yeah, absolutely. It's really helpful because we get to see those gaps in redress, and then we can work with policymakers to identify where those are and look to close them wherever possible on those. So the other question, the next sort of question that we've got is again related to accessing the Housing Ombudsman service. So this is from Nicola. What is the best way to help clients when social housing, council and housing association are controlled by an ALMO, so an arm's length management organisation? Kirsty, are you happy to take that one, or are you?
Yeah, so in the first instance, if someone's raising concerns, it would be best for them to speak to their landlord, be that the council, if it is an ALMO in place, and they should have the ability to pass on those concerns if the ALMO's managing the properties on their behalf. If the resident uses the internet, as part of the duty to monitor work that Verity and my team are doing, the landlord, if they have a website, should make it really clear to who the resident raises a complaint if they're unhappy. So phone number, email address, online form, postal address, and a policy setting out how the landlord will deal with that. So if the landlord has appointed a tenant management organisation or an ALMO to deal with services on its behalf, its website should be really, really clear to explain how that operates in respect of complaints and services. So I would say it's probably worth checking with each individual complaint before you raise it. But as a point of principle, ultimately, the landlord is responsible for delivering those services and responding to the complaint. Although they might choose to have a managing agent do it on its behalf, that doesn't mean it's no longer responsible. So have a look on the website. If there's any queries about it, I would suggest going to the landlord directly.
Absolutely, and I think that's the important thing, is that, you know, we do see where, you know, a significant amount of landlords do successfully resolve their complaints directly with their tenants, and that's what we really want to encourage, because not only is it putting things right more quickly, but it actually helps to rebuild those relationships, which is really important, because actually it's an ongoing relationship there. It's not, you know, kind of moving. It's not going to be something that they're not going to engage with again in the future. The next question, there's two actually that kind of work together really, which sit together really nicely. Oh, thank you very much, Chris. It's from India and one from Peter, which are both about what makes a good housing case referral to the Ombudsman to avoid delay and assist the Housing Ombudsman investigating the case. but then also when a complaint is made, what are the key things that should be included by the claimant? So those sit quite nicely together. So we would say, as you know, we've highlighted that when a resident is making a complaint, that they are really clear what they're unhappy about, what it is that has happened, with any key timescales or specifics about what's occurred, where they can remember or where they're aware. That will help the landlord to identify how far back they need to review and consider. It's important for them to set out how that's impacted on them, and also anyone that is in the and in the property as well, so that the landlord can make a clear and fair assessment based on those individual circumstances. So, for example, loss of a downstairs toilet for for one family could make a very big difference, whereas another family it wouldn't, depending on those individual circumstances. The other thing which I'd always highlight as well, and sometimes this is the part that gets missed when you're thinking about making a complaint, is that actually setting out what you're looking for to resolve the situation, and being clear on what that might look like. It's something that's very helpful because it will help the landlord sort of really consider, can we, what is it that they're looking for, and they won't preempt what someone is looking for. And I've seen that used really quite creatively, where people have said, well, actually I'm not looking for huge vast amounts of compensation, I just want to know it's not going to happen to somebody else. And it's really important that the residents' views and considerations are there for them to think about. Where a resident is claiming or requesting compensation, particularly for, say, damaged items or things costs that they've incurred, we'd encourage them to have any evidence of those costs. But I'll just highlight that just to be very mindful about any original documents. So, being clear that actually they may well need to take a copy rather than providing an original. We have seen problems with that in the past. So that's those ones.
Sorry, I just wanted to kind of build on a couple of points on that. And that's just to say, if a resident has kind of experienced a number of different issues in their home that they are unhappy with, and then this last complaint is the straw that broke the camel's back, they've had enough, they're now raising a formal complaint, the temptation can be to suck in everything that's happened into that complaint, and that can make it really challenging to understand what the specific issue is being complained about. So rather than, if the resident wants to kind of bring in a history, so a classic one might be roof repairs, it might be helpful to have brought in, over the last 4 years, you've carried out a number of repairs to the roof, they've not been successful, and this is now culminating in where we are. But bringing in lots of different unrelated issues can make it really hard to understand what this specific complaint is about. So trying to keep it focused will mean the response is much more likely to address the current concerns. And the other thing I just wanted to say is, although the revised Ombudsman scheme says a landlord should accept a complaint up to 12 months after something has happened, we'd always encourage the resident to make that complaint at the earliest time they're able to. And that just means when the landlord investigates it, it's fresh in everyone's mind. If it's a dispute about, something a contractor said or whatever else, it's much more likely to be fresh in someone's mind than trying to recall something that happened 11 and a half months ago. So we appreciate sometimes residents want to see, okay, landlord said that they'll put it right, I want to give them a chance to do it. That's absolutely fine. If it then falls through, make the complaint, but really try and make that complaint as early as possible, so when it's investigated, it's as fresh in everyone's mind.
Lovely, thank you, Kirsty. Those are really good points, particularly around the timings of those complaints. leads me on beautifully, so perfectly segues into the next question, which is about, is there a time limit for the Housing Ombudsman to consider a case? And yes, there is. That is set out in our scheme, which is that residents have up to 12 months from the date of the final response to refer their case to the Housing Ombudsman. So that, yes, that is that full 12 months. The number of those that we receive, I have to say, are quite limited. Most people are very quick to bring their cases to us, but yes, absolutely, we do can accept for up to 12 months for those. There's a number of other questions, so just moving on into sort of some of our jurisdiction questions. So what do we cover, and how do we work with other organisations? So there's one from Thomas who's asked whether councils have neighbour problems and complain to the council and their council tenants, and it escalates. Should we refer to the Housing Ombudsman or local government ombudsman? What are the different areas of responsibilities? Where the relationship is broken down, are there alternatives to the ombudsman bodies? So Chris, I don't know if you'd like to take that one.
Yeah, sure. It is a sort of jurisdiction classic, that one, because there is overlap. So the reason there's overlap is because the local authority has potentially two roles here. So one, it's acting as the landlord, and then two, it's got its environmental enforcement team who deal with things like statutory noise nuisance, and they're separate departments, separate teams. And ASB noise obviously can drift across both of those teams. In most cases, it's likely to be us rather than the LGSCO, because in the same way that we would expect a housing association to investigate and respond to reports of neighbour ASB, a council acting as a landlord, we would also expect to carry out those same functions. So definitely for kind of lower level ASB, between neighbours, neighbour disputes, we'd expect the housing team to be actually going in and investigating those things. So that would come to us. But yeah, then it can certainly escalate and involve environmental health and maybe their statutory noise nuisance. So it can drift across. But I'd say, as per always, it depends. It's on a case-by-case basis, but we do investigate a lot of cases relating to antisocial behaviour for local authorities. So I think it's likely to be us in most cases. We also work much more collaboratively with the LGSCO now. So we meet regularly. We have systems in place to do joint investigations. So if either ombudsman picks up a case where it's mainly us, but there are elements for the other ombudsman, we can kind of meet with them, discuss it, and decide whether it might be suitable for a joint investigation where we kind of work together, issue one decision. We've both looked at our various parts. But yeah, in brief, probably us. And if we need to bring them in, we can, or refer a small part of the complaint to them, we would do that.
Absolutely, and just to add to that, what we encourage councils is to actually to make residents aware of both organisations so that they can approach and get the right information. You know, we don't expect residents to understand or unpick jurisdiction. I'm sure my colleagues are having a little wry smile of the discussions that we also have. You know, jurisdiction is complicated, and you know it really isn't for them. For yourselves, and apologies, I've got workmen in, that's why I've just needed to move very quickly. I don't know, Chris, if you mentioned the memorandum of understanding that we have published on our website. So that is there for you. You can actually see that. So we might be able to pop a link into the chat, and apologies if that's already been mentioned. But the responsibility of making that decision sits with us. So if in doubt, you can refer to either and you will get, you know, a response on those. Just moving on, and again, there are some here which are sort of repeated. So Dana asked about if one of the parties is not responding, what are the next steps? So I think I've covered that in powers. So we do have that, the power to intervene and require a response. And similarly, Warwick had the same question, and so did apologies. And I think it was those two. So those two covered, but if you do have any, thank you for sharing that. So Kirsty's just shared the memorandum of understanding. There have also been some several questions which were really related to sort of some broader aspects. So India has asked, when dealing with housing associations, what is the most common problem that is arising, and is anything being done at a national level to rectify this from happening? And then also, bear with me, Samantha Green has asked, what do you feel is the biggest challenge our clients are facing? And Diane has highlighted about common themes in which we will be quite often, well, you've said which most likely to win compensation. We don't award compensation in that way, but the things which are most likely to be providing. So Chris, I don't know if you want to give a bit of an overview of the types of cases that we've been receiving and seeing a huge amount of. I don't think it'll be a surprise to anyone in the room.
No, it's we see a lot of disrepair cases. I guess sort of disrepair, damp mold, and then antisocial behaviour. There are sort of the main cases we'll look at. It's interesting. So the questions there, anything being done at a national level, and there's also another one about Cornwall Council not meeting statutory obligations. So to sort of answer those, we're sort of very, I guess we've talked a lot about making orders for landlords to put things right. We're also very aware of the sort of operating environment that landlords are in, and that it is incredibly challenging for them in terms of resources, in terms of all landlords having sufficiently skilled staff to do the things that they need to do to meet their obligations, or the things that we say they should be doing in the damp and mold report. There are a lot of challenges, and I think we fully recognise that. In terms of sort of particular doing things at a national level and maybe recognising problems with other landlords, this is where our sort of learning comes into it more, and our spotlight reports. So we'll kind of look at the data we have on the types of findings we're making, and if we see patterns, then we'll look at that, and that's how we'll determine the sort of area to focus on and maybe produce a spotlight report on, or do some digging into what we're seeing and trying to get to the bottom of why that is. And that includes particular landlords. So you'll see in the past we've done special reports on particular landlords. So where the data shows that there's a really high level of maladministration with a particular landlord, maybe on a particular subject, then we can carry out a special investigation into that landlord, do more work with them. But it's all really, although the sort of impact of those reports is quite hard hitting in the sector and sort of reputation wise, it's all really focused on trying to drive improvement and work with those landlords to help them try and understand what's gone wrong and put plans in place for improvement. So, and I guess that's it again, the question about what we're doing at a national level. Our spotlight reports, good practice reports are all just based on our learning. So everything we do is based on what we're learning from what we're seeing in our investigations, and we pull that together in a meaningful way to share with others. So landlords don't have to do the same learning individually. We can kind of group that together for them and say, look, this is what we've learned from our casework, and try and drive improvement in that way. But yeah, we totally accept, and a lot of us come from a housing background, so I think we understand the challenges around resourcing, money, skills, employment are massive as well. But that's, I guess, what we're trying to do to sort of through those reports and investigations.
Yeah, absolutely. And I think what's also important is that we do work very closely with the regulator of social housing. So we have an information sharing agreement that's due to be published. So our memorandum of understanding is due to be published. So sharing those insights from what we are seeing from individual cases to support the regulator in deciding in terms of targeting their regulatory practices and whether they need to provide additional support. Both the Ombudsman and the regulator meet regularly with the Department of Levelling Up Housing and Communities, so that the insights from both of our work can be used to inform future policy decisions. So being able to do that. So and beyond that, you know, Rick, since he's been in in post, he has attended select inquiries to look into the readiness of the sector. He was also asked to provide information to the coroner's report as part of the death of our Awab Ishak. Unfortunately, you know, really heartbreaking, and we were asked to provide and submit evidence. Our most recent call has been for a royal commission to look at the state of, you know, this essentially the provision of social housing. That's from the back of our attitudes, right and respect report, which I think Ray has very kindly shared in there. So there is a huge amount of that. So we inform the sector and we look to influence future decision making where we can, and work very hard to do that. So that's those, and hopefully Sheila, it was you that asked the question about Cornwall Council, so highlighting those. There was also a similar question related to a specific organisation, which was Jean, who was asking about considering whether a precedent might be set up with the outcome of a Birmingham City Council case regarding managing to expedite or not negotiate possession orders. As that's something that relates specifically to court, it's not something that we're really in a position to give comment on, I'm afraid, on that one. So those were the specifics. Thinking about specific landlords as well, Juliet asked for some information about our recent dealings in Colchester. It's obviously a local interest there. So we've been able to provide some information just covering the east of England and the statistics for 24-25 to date. So these are hot off the press information. So covering the east of England, we've had 300 findings with a 74% maladministration rate. So still looking at that 3/4 of cases that we're looking at, we are finding elements of maladministration. The main complaints being raised there, again, not a surprise, unfortunately, which is leaks, damp and mould. So really relating to property condition in that specific space. Very conscious of time, so I'm just going to gallop through some of the other ones and just highlight which ones which we sort of think we've highlighted. So Avril's asked a question about how effective are we at getting landlords to deal with disrepair, and what do we do if a landlord doesn't comply with recommendations given by the Ombudsman. Charles has asked a very similar question about understanding better our statutory powers to enforce our decisions, similar from Natalie, and then also Juliet as well. And they've all asked very, very similar questions, which is about our powers. So as we've said, we do have those powers and track them through to completion. We really closely monitor landlords to make sure that they do comply. And we've done a lot of work to consider what compliance looks like, which I think is really important. And I know Chris has been part of our work looking at compliance and what does compliance look like. Not just accepting an email saying, yes, we've done everything, but really looking for that evidence. Chris, I don't know if you want to add anything sort of specific on that one. I know we've covered powers quite a bit, but on the evidence provision? Yeah,
and you know, I guess this is where we've done some learning too, like I say, particularly around damp and mould, and we're continually trying to refine our orders. As sort of Kirsty said right back at the start, we have very high rates of compliance with our orders. So it's to be honest, it's not an enormous problem. Landlords will nearly always try and comply with our orders, but then how we word our orders is also crucial. So to take a damp and mould case, for example, we could now do things like, if there's an ongoing damp and mould problem and the landlord have tried several things and it's just not really resolved, we could, for instance, order the landlord to carry out an independent specialist survey of the property, and then to implement any recommendations or works that come from that report. and set timescales for that. So say, 4 weeks to do the survey and maybe another 8 to complete the work. So we can be really specific now around trying to make sure that it does get resolved. And if we don't think the landlord looks like it's capable of doing those investigations and works itself, then we can order it to be independent. So those things are quite effective. If you get the right people in, you get the right skills in, there generally is ways, taking the damp and mold case, improving ventilation, kind of insulation. There's all kinds of things that can be done to sort of mitigate and sort of reduce kind of nearly all damp and mold situations. So a lot of it's about us getting the orders right. And if we get the orders right, then the compliance is generally there. So there is quite a lot we can do. And so I think we are now seeing some real success in those kind of orders that we're making, and actually getting situations resolved. On the back of that, landlords are having to put a lot more resource into their damp and mold teams to sort of carry out that work that we're ordering them to do.
Oh, that's great and really helpful. And again, as Chris has said, we've learned ourselves where, actually we have, had instances where a landlord has said that they complied and the resident themselves, unfortunately, has had to then provide evidence that that hasn't been the case, which is what has led us to, really increase that that oversight, which is really important to the work that we do. I think that we have now covered all of the questions, maybe not specifically by name, but we have covered, I think, all of those key topics. What we will do, and we're happy to provide some of the we can give written responses just so that people know that they've had, that what that specific response was. More than happy to do that, but conscious that we've got 15 minutes to answer any kind of live questions. And Ray, perhaps you would be happy to chair that for us.
Yes, absolutely. So we're going to go to the final section then, the live Q&A. I know Kirsty's done an amazing job of answering your questions in the chat, but if you feel that you still want to get some, build on that question, feel free. We're going to do raise the hand function, if that's okay, just because there's quite a few in the room, or if you're not comfortable with that, we're very inclusive here at the Housing Ombudsman, so please put it in the chat and I can read it out to kind of try and chair this bit. We've got Diane and Vicky guessed straight off the bat. Do you want to put your mic on and ask your question?
Yeah, hi. My question was, you spoke about ordering landlords to carry out certain actions, but ultimately, what's the ultimate sanction if they don't comply?
So the ultimate sanction that we could take, and I would be amazed if we ever got this far, I have to say, would be for an individual order, we can apply to the Secretary of State to request that we take that order and that landlord to court, and to have it confirmed in court for that action to be completed. We also have powers where if a landlord was refusing to comply, that would mean that they were in breach of their membership obligations of the of the Housing Ombudsman scheme, and ultimately we may consider removing them from the scheme. The impact of that would be absolutely significant, because obviously, firstly, going to court, but secondly, for a social housing landlord, membership of the Housing Ombudsman is mandatory, and therefore that would potentially, it would very likely risk their recognition and ability to comply with the regulator of social housing, which, ultimately all the way down the track, if you followed it all the way through, would mean that they might be ordered to cease trading. Now, the chances of that happening are very, very small. We do we already see very high compliance. It'd be highly likely that the regulator would step in to ensure that that wasn't the case. But those are the ultimate sanctions we could have.
Thank you. Just in the meantime, without a hand up, can I just ask, a question came up in the chat, I don't think it was answered by Bernadette. Can a result be much quicker if you try the mediation option? I guess it's about complaints locally. Can anyone handle that question, please?
Yeah, absolutely. So, I was going to say, I said absolutely, and I was going to bring in Chris, so that's perfectly timed without even realising it.
Yes, it would be. So because mediation would happen before the point where we request evidence from the parties, the case wouldn't have to wait for investigation from an investigator or an adjudicator. So yes, absolutely. It's a huge bonus for both parties, and why mediation is great when it works. So it would be much quicker. It would actually happen when it reaches what's called our triage team, which we haven't discussed, our triage and mediation team, which sort of once we have the case has come to us, we've done some checks, we know that the landlord has provided a final response. It then comes to sort of the triage and mediation team who carry out that assessment. They also do the risk assessment and kind of consider how the best way to resolve the case is. So yeah, that would be much quicker than the timelines we've discussed when we're talking about investigations.
I think just to add to that as well, one of the things which we're always really conscious of, and I've fully disclosed, I was part of a large landlord for 12.5 years before I joined the Ombudsman, so I'm afraid I'm poacher turned gamekeeper, is that we're very aware that, you know, things offered to residents through mediation may feel very, very attractive, and, you know, it's within their right to agree to that mediation, but the Ombudsman does retain the right to continue that investigation even if the resident is satisfied. And the reason that we retain that power is that, you know, if we were to see, for example, a resident being offered £20 and then the landlord providing them with £2,000, that would be quite interesting to see their reasons and to understand why that's the case. So we do still retain that.
Thank you. Diane and Vicky, I think your hand was raised again. Do you want to come in?
Yes, please. Thank you. When there's awards against housing associations for repairs or compensation, what powers does the Ombudsman have to enforce that if the landlord doesn't comply or is a long time complying? What are the enforcement powers?
So we don't have enforcement powers in the same way that the social housing regulator has. So our powers are to ensure compliance. So what we would do is we would initially, we would be, you know, asking them to provide that evidence. If they fail to do so, we can issue them with a complaint handling failure order. That is shared with the regulator of social housing, and we'll order them to comply with that requirement. That goes to the board and it goes to the chief executive, so it is escalated as a governance and oversight requirement for them to do so. If they don't comply with that, then that would be where we would be making a decision about whether we would be requesting approval from the Secretary of State to progress that particular order for court action. Chris, do you want to come in on that one?
I was just thinking one other thing to say. It's incredibly rare, to give you some idea. In fact, I can't really think of a time in my 9 or 10 years when a landlord has refused to pay compensation. But just to explain a bit further, the options for the landlord would be, if they feel that our decision is unfair, or they have further evidence to support why they did what they did, then they can request a review of our decision. So that would be if a landlord did disagree with the decision and felt that compensation we awarded wasn't fair and we hadn't looked at something or challenged the evidence we relied on, they could request a review of that decision, as can the resident, of course. So both parties can request a review of our decision under certain circumstances. Having been through the review process, the decision could be changed, the orders could be changed, but if they're not, we would then, again, the landlord will be obliged to comply at that point. So I guess a landlord that didn't want to comply would go through that process first, and if our decision was upheld, they'd be expected to comply again. And again, I don't think I've ever seen at that point a landlord sort of refuse to do something that we could. But again, as Verity said, it's much more reputational now because everything we do is published. So for a landlord to refuse, we could do a special report on that. We could highlight it to the regulator. The sort of reputational impact is really significant, which is why really we just about have close on 100% compliance with all our orders. Eventually, there are problems with delays for sure, but the compliance does get there.
Thank you. I can't see anyone's hands up. I know a question came up earlier again. Just, I guess, to bust some myths about the process and how long it takes. Can anyone just kind of just walk through, you know, how long it typically takes for someone to raise a complaint to the Ombudsman and that to be resolved?
So in terms of our processes and timescale, so when a resident is first contacting us, they can do so via email, they've got the web form, there's lots of different avenues. Now we aim to respond to a new registration, so that new first contact from a resident within 10 working days, so 2 weeks, to acknowledge and confirm that that case has been raised. I'm not aware of where our performance is at the moment.
Is that, sorry, it used to be 15 working days.
Apologies. As I looked at you, I suddenly went, no, that's it. Sorry, 15 working days for a new, thank you, Kirsty, for a new registration to be raised. That would be then assessed and reviewed and then either resolved by giving advice, which we would then, you know, aim to do that as a first contact resolution, or for intervention, where we would take those through for resolution through the landlord's own internal complaints procedure, and we would aim during that process to be responding in the 10 working days to any of the contact that was made, so that we're then able to give that update. The timescales for resolving those complaints really will be hugely varied because of the time, you know, the time of that individual case. So even at stage 1, if there's 10 working days to provide a response, a resident may then decide that they want to wait for the outcome before they decide they want to escalate, etc. So that dispute support section, if you like, that initial contact can really vary, and because a resident can contact us for up to a year to request that case be investigated, I mean, it can take up to, you know, it could even be a year and a half by the time they've gone through all of those. So in terms of from that side, once a case has been referred to us, the teams are then contacting residents, and that, you know, we will depend on caseworker availability and the severity of that particular case. It will also depend on whether a resident has needed interventions previously. So we aim to keep it with the caseworker for as long as possible on that side of it. Once a case has been accepted, that's when we'll do our assessment. And as Chris said, it is very dependable. You know, it's very dependent on those individual cases. And whilst I would love to be able to say it will take X amount of time to reach this stage or that stage, without knowing the individual cases, not in a position to really share that or to give you oversight of that in this meeting, I'm afraid. I just don't want to give false impressions or to give him, you know, an inconsistent position, because it really will vary, and rightly so, from case to case.
Marvellous, thank you. Well, I think we're around about time now, so the hands certainly aren't raising, there's no more in the chat, so I guess it's time for me to do the shout outs. Thank you very, very much to Amy from Citizens Advice for helping us host this session. We really appreciate that. Thank you, Amy. Thank you to the Dream Team, Verity, Chris and Kirsty, and the big thank you, of course, for you all to be here. We really, really value your time to help us help your clients. So thank you so much. We will be sharing the video and the transcript that Verity's pressed the button on for your colleagues. And yes, thank you very much, and enjoy the rest of your day.
Okay. Thank you very much, everyone.
Thanks,
Bye.
everyone. Bye-bye.
Thank you.
Thanks. Bye-bye.
Bye.
Thanks a lot.
Thank you.